Okay, chapter 7, video 3. Now we're talking about strict liability and what the courts have adopted as the so-called foreign substance rule. This usually applies to food. I assume it can apply to other areas. They hold that a product is unreasonably dangerous if it contains a substance that is foreign to the product. Most courts reject this approach and say that even if it contains something that is natural, the product can still be unreasonably dangerous. So don't confuse these. This simply means that it's a broader approach and says that anything, even if it's something natural to the product, it can be unreasonably dangerous. So I suppose there are people today that argue that you better put warnings on anything that contains peanuts because there are so many people now that are allergic to peanuts, and that could make it unreasonably dangerous to that individual, even though it may be a natural ingredient in something. What we're talking about up here is the foreign substance. A real interesting case was a case involving clam chowder. And it occurred somewhere in New England, and somebody ordered clam chowder at a restaurant, and when they went to eat the clam chowder and they bit down, they bit on a shell which cracked their tooth, so they sued, saying it was a defective product because it had a foreign substance in it, a shell. And the court analyzed the case and said that, this is a situation that is maybe geographic in the sense of how we view it, because anybody in New England knows that it's not unusual for there to be shells in clam chowder, and therefore it's not really a foreign substance. Okay, but that rule might be different in some other state where people are not familiar with clam chowder. Typically, I remember when we were in law school, the cases that we always read, and I don't mean to upset any of you, but were the cases where when most of the soda was bottled in bottles rather than cans or whatever, people would find things like parts of mice, parts of rats, and those things. That was strict liability. You didn't have to prove any kind of negligence on the part of Pepsi or Coca-Cola. You just showed that what the product contained. You may remember a few years ago that person tried to put a finger in something that they bought at Wendy's, alleging product defect. Of course, that was because they put it in there. But anyway, that's the foreign substances rule. Unavoidably unsafe products. There are some products that it's impossible with current knowledge to make them absolutely safe. So if the benefits of those products outweigh the risks, the courts are not going to hold the manufacturers liable. Okay? Here are some of the types of product defects that we come across in litigation. Defect in manufacture. Okay, so that's where perhaps a bolt that was needed to hold something down had a crack in it, and when the product was used, the thing gave way and somebody was injured. A defect in design. That was the Ford Pinto case. They shouldn't have put that gas tank behind the rear axle. They should have put it in the middle of the car. That was a design defect. A failure to warn. Okay, this is one of my favorite ones. So I always ask the question, can you think of products that have warnings on them? Lots of products have warnings on them. But my favorite product, there's a product that's my favorite one that I think has the most warnings of almost anything I've ever seen. I'm sure there are other ones, but this is one that always comes to my mind. So think about it for a second, and I'm going to tell you what it is. Okay? Next time you do some work around the house and you pull out a step ladder, look on the side of the step ladder. Step ladders have probably been one of the greatest areas of litigation because people are always falling off of them and they're always blaming the ladder instead of themselves. So if you look on the side of the ladder, it'll say things like, do not step on this with wet feet or without shoes. Don't use near electrical. Why? Because it can conduct electricity and electrocute you. Don't go above a certain step on the ladder. Those were not made to be stepped on. Do not use more than 250 pounds on this ladder. Make sure that the ladder is open completely and secure. All those things are put there to warn the public and to protect the manufacturer from somebody saying, well, I didn't know that the product was dangerous when used in this way. Another is defect in packaging, and that's simply where they package it in such a way that it causes the product to be defective and injure somebody. Okay. So this is what a manufacturing defect is. We already talked about that. And this is when the product departs from the actual design, so it's not a problem with the design. Sometimes the problem is that the manufacturer failed to exercise due care in the maintenance, assembly, or testing of the product. Okay. You don't have to show why the product was defective. You only have to show that it was defective and the defect was unreasonably dangerous at the time of purchase. Design defects, here you see that. We talked about that before. The test is that the plaintiff must show the defendant's failure to use a reasonable alternative design and that rendered that product not reasonably safe. Okay. The test that's used is the risk-utility analysis or the consumer expectation test, and we basically talked about those before in another area. The risk-utility analysis determines whether the risk of harm from the product outweighs its utility to the user and public. The consumer expectation test looks at whether the product is unreasonably dangerous when it fails to perform in a manner that would reasonably be expected by an ordinary consumer. Design defects. Here the product conforms to what the planners intended, but something is wrong with the design. So it's manufactured properly, but it doesn't matter, it's defective because of its design. There's an inherent problem with the product, and the key element is that the defendant chose a design that posed an unreasonable danger to the plaintiff in light of the availability of a affordable, safer alternative designs. Okay. Now, an exception and an interesting one is automobiles. Okay, so the design of automobiles. All right, so many years ago, the courts carved out this sort of exception for automobiles, and we call that the crashworthiness of automobiles. So this is sort of the theory behind this principle. And the theory is that unlike most products, we know statistically that most automobiles are going to, at some time or another, be in some type of accident, whether it's a serious accident or just a fender bender. So we are going to require that manufacturers make cars a little bit crash-worthy. Okay, they don't have to make a car so that if you're going 100 miles an hour and you run head-on into a 18-wheeler going 100 miles an hour, that there's going to be no damage to your car, or even if there is, you're going to survive. No, we're looking at lower impact types of cases. As a result of that, manufacturers have to make steering wheels usually so that they can take the impact of your body going forward in an accident. The dashboard is padded. Gas tanks and other components have to be somewhat crash-worthy. Okay, and the federal government, through the Transportation Department, usually sets regulatory standards for that. But that's a little bit different than your ordinary defect, because the car is defective only because it wasn't built up to a certain standard. Okay, so design defects can fall into these categories: structural defect, absence of necessary safety features, and misuse of the product. Okay, now misuse of the product is interesting because if the manufacturer can anticipate the misuse of a product by ordinary people, then the manufacturer has to take that into consideration in designing the product. Okay. All right, we talked about structural. Inadequate warnings is where the product is defective based upon inadequate end-using warnings or instructions. We talked about ladders, etc. So we see these rules as well. Okay, and I talked about foreseeable misuses. This is the test the courts use about the warnings. You don't have to give an obvious a warning about an obvious risk. Okay, so you probably with a lawnmower do not have to tell the consumer that they shouldn't pick up the lawnmower while it's running with both hands and try and use it to trim bushes. Okay, that would be an obvious misuse and cause a risk of harm. Okay, I'm going to stop there. We'll pick back up with using negligence in a product liability situation. Remember, the magic word for this chapter, chapter 7, is absolute.